To the 294th District Court, my name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Anthony Collard. Here. Chase Enix. Here. Ryan Klassen. Ryan Matthew Klassen. Here. Luis Leja. Here. Wendy Paul. Cause number CR 2352. I believe that we have Ms. Paul TDC custody and Marlon, so we'll call that something. Bart Jones. Here. Dakota Blake Dole. Mr. Dole has provided the court with medical documentation indicating that he has the flu. The court has reset him to February 15th. Mr. Manning. Michael James Glasgow, CR 23215. Confirm that Mr. Glasgow is in Henderson County Jail. He is mentioned. So we'll call that. Ryan Higgins. Here. Ginger Malkovich. Here. Or I'm sorry, Malco. Marty McCormick. Here. Patrick Rowe. Bobby Shaw. Here. Brad Brewer. Here. Jonathan Curtis. Here. Ryan Dancer. Here. Guido Dingemans. Here. Zachorian Fulbright. Dallas Hightower. Here. Dustin Howard. Dustin Blake Howard. He is in TDC?
Yeah, I'm pretty sure he's still on TDC.
Karen Lyons. You say here. Sorry. Jason McDonald. From that Mr. McDonald's also in TDC custody, CR 23151. We'll recall that. Keith Meredith. Here. Christopher Nash. Here. Joshua Nowak. Here. Daniel Schmidlkoffer. Here. Deanna Williams. Here. Preston Wilson. So we have Preston Wilson confirmed confined in Henderson County on a federal detainer. Mr. Schmidt, that's what we call that. Andrea Young. And Ms. Young, I believe Mr. Thorson's on a Zoom hearing across the hall. So he'll step in here in just a moment. Tiffany Light. Here. All right. The rest are at 10 a.m. We'll recall those at 10 a.m. We have any counsel that's ready? Manny, be ready on.
I'm ready on.
Who would you like to call first, sir?
If we want to start with Mr. Higgins.
Mr. Higgins, if you'll come forward, sir. This is cause numbers CR 23-128, 129, and CR 23-196. State versus Ryan Matthew Higgins. Show two cases set for docket call and a DWI second pretrial.
That's correct, Judge. We have no contested pretrial issues. I spoke to the state last week, received an offer. My client and I had a meeting yesterday and discussed that offer, and he's weighing his options at this point in time. We requested that all those cases be set for docket call.
I'm not sure. Did you say no pretrial motions?
No contested pretrial motions.
Okay. All right. Court sets Mr. Higgins in for docket call. Set him on the evidentiary docket the 29th. Otherwise, it's going to push us out to evidentiary docket on the 28th of March. Unless Mr. Higgins only needs a few weeks, we can do 15. That's only 2 weeks. It's just to consider offer and decide whether he accepts it or not.
Judge, one of the offers would be for pen time, which would require him to kind of wrap his business up. So if we can have just a little bit longer.
February 29th.
Judge, that'll work.
All right, court sets Mr. Higgins for docket call, like all cases, February 29th.
They can be excused.
Be excused.
They can do it. Next ready on Ms. Malco.
Ms. Malco. CR 23-16. State versus Ginger Lorraine Malco. Docket call. Go ahead, Ms. Sweeney.
Judge, state and I have reached an agreement to reset this case. We're waiting on the status of the co-defendant's case. We'd asked for this one to be set out a little bit longer due to the nature of the investigation that's going on in that case.
How much time?
Your Honor, the co-defendant is also set today. I think we might have a little bit more information, once he's had once we get that update. We don't have an exact timeline at this point.
Do we need to recall it after the call to put in its case?
I'd be fine if you want to set to the March, that's the docket. I don't anticipate we'll have anything dispositive at that point in time, but at least we'll have a better time of what we're looking at.
All right, court will set Ms. Malco for final docket call on March 28th. Mr. Manning, I've got notes here from the pretrial release saying that the client's reporting is unreliable. Yes, meaning that she's not reporting what she's supposed to, and that she's delinquent close to $500 on the pretrial release.
Yes, Judge, I'll speak to her about that.
Ms. Malco, can you make a payment today towards your pretrial release fees? How much can you pay today?
I can do $75.
All right, then after court, I'm gonna order you to leave the court and go over
Yep.
your $75 and bring your receipt back over here to Mr. West.
Okay, to Ms. West.
He's
He's the pretrial release officer. So just bring back and show him that you paid your $75.
Okay,
And Judge, she is reporting to Officer Clark as well. Judge, next on, ready on Mr. McCormick.
Mr. McCormick. This is cause number CR 23-188, State versus Marty McCormick, pretrial.
Yes, Judge, we received all the discovery in this case, reviewed most of it with my client last week. At this time, we have no contested pretrial issues and requests to be set on the docket call. However, Judge, I would note we are still waiting on an offer. I've requested that multiple times. We would just request that if there's an offer be made, we have that before we reach our docket call announcement.
Does the state intend to make any offers in this case?
Yes, sir. I believe we are kind of headed in that direction. We'd be happy to have that conversation with counsel.
All right, I just asked the court, I'm sure that the state make its offer in sufficient enough time then to have certain time to be able to review that and make a decision. All right, court will find no pretrial motions and we'll set this hearing docket call on February 29th.
Yes, Judge.
Also show that Mr. McCormick is delinquent $170 on his pretrial release fees. Mr. McCormick, can you make a payment today?
Maybe Monday.
Monday? How much are you gonna pay on Monday?
I pay 90.
All right, I'm gonna order you to pay $90 on Monday. Bring that receipt with you to court next month.
Judge, I know Mr. McCormick had medical issues and surgery recently, and so that may be where the delay was. Judge, ready on Mr. Rowe.
Patrick Ray Rowe, CR 23-116-117. All right, Mr. Rowe, set the pretrial.
Yes, Judge. If you recall, our last setting, we had requested a reset for issues with discovery. I got an email from the state, I believe within this past week, they fixed those issues with discovery. It's now working. It is a lot of data that's gonna have to be sifted through, so I request a little bit longer reset if it possibly bump this out to March.
And state would agree, Your Honor, having gone through part of it, I expect Mr. Manning would need 2 full days to go through it in our office.
All right, court will reset Mr. Rowe for pretrial hearing on March 28th. I'm sorry, yeah, March 28th, that's next Thursday, I believe I have.
Thank you, Judge.
And I showed Mr. Rose delinquent of his pretrial release fees, $450.
Judge, he has confirmed that he sent payment for $525, and that was. It just looks like it hasn't processed through.
When was that? This morning?
$525.
All right. Try not, don't let it get that delinquent. I won't have that concern with you, okay?
Lastly, Judge, I have Mr. Bobby Shaw.
Bobby Jean Shaw, CR 23-118. Shaw set for Dr. Call.
Yes, Judge, at this point in time, we're still waiting on an offer on Mr. Shaw's case. As you might recall, I was appointed to handle this case after I was appointed on an arson, evading, and criminal mischief. However, at this point in time, those cases still have not been indicted. The state has told me they intend to continue to go forward with those cases, but at this point in time, we're still kind of in the on Mr. Shaw's case.
Response from state.
Your Honor, we anticipate presenting those cases, and indictments should be within the next 30 days, I would imagine. So at that time, we'll be able to really discuss all 3 cases in earnest and see if disposition is appropriate.
All right, court will set Mr. Shaw for Dr. Call on March 28th. Mr. Shaw, I show that you're doing $660 on pretrial.
Yes, sir. That was on a case of 2016, and I still payment.
No, this is not on a case from 2016. This is on this case.
Oh, no. I mean, I've been paying payments ever
Yeah,
since.
it's not a KBS profile. I'm not talking about a case.
I got the receipt right here.
For how much? How much did you pay?
I paid 100 on one, and paid 50 on another one, and I paid, started another one 30. They said I had for 2016.
Right, so what I want you to do, Mr. Shaw, I want you to go and meet with Mr. West and show him your paperwork there, so I can make sure that I get documentation for me.
Can you tell me what case exactly it is? Because we did this last time too, and he said I was current on that. I just want to make sure I get the right case that you're talking about.
I'm assuming it's going to be on all of these cases, including this one, and all of your new unindicted cases are going to have pretrial reporting fees
Yes, sir.
and attorney fees.
Okay. Well, I had
It's
that.
going to be a combination of all of those cases. It's not going to be with regard to anything that you've done in the past that you've been either convicted on and sentenced, you've been ordered to pay fines and fees, etc.
Okay.
Judge, I guess my question, I'm not as familiar with the system, but I guess if he's on pretrial release for multiple cases, it should just be one reporting fee, correct?
Not sure if someone else put him on pretrial, a magistrate could put him on.
Okay. Judge, I'll speak to the probation department, and see if we can get that figured out, but I do show he has paid on his pretrial release.
So the total.
Talked to the probation department, they wrote $660 online.
Okay, that's what she told me yesterday on that one, the case that it just come online for me to pay. It was a
Hold on a second. Judge, I just got word from Ms. Burns that he's good.
He's what?
He's good.
He's paid up completely, 600, no, he's not
That's his
delinquent at all.
balance.
Huh?
I wrote the wrong thing down. That's his balance.
All right, sorry, Mr. Shaw.
That's good.
Free to go.
Thank you.
Oh, just- I believe that concludes my business. Might be excused for this afternoon.
Yes, thank you. Almost me here, bro. All right, Mr. Hall, I understand you're not feeling well, is that correct? All right, this is sanctions court hearing, CR 2021. Mr. Pollard, I ordered you to do three things in the last setting: pay 60 to probation, pay 80 to court, work 20 hours community service. It says that you didn't do any of those, correct?
Oh,
You did them all? They say you didn't do them all.
I'm doing what the first minute today.
No. You were supposed to do this before you came back to court. Are you telling me that you paid your probation fees, you paid your post selection fees, and you already worked 20 hours community service?
I haven't done community service yet.
Did you pay the other two? When did you pay those?
I can do.
You know, that's due the Friday of the week before you come to court.
I didn't know that. I don't have vehicles and they're 88 miles away from where I come from, so. I feel that, you know.
All right, so what we're gonna do, Mr. Caller. Next month, I'm gonna order you to do the same thing: 60 to probation, 80 for sport collections, and 20 hours community service. I'm gonna do 3 days in jail for every 1 day for every one of those if you don't complete. Okay, so I'm gonna order you to 3 days in jail, and if you comply by paying your probation fee, your court collections, and you do your community service, then I'll take those 3 days away. Understand? Understand what we're doing? 20. I'm gonna order you to serve 3 days in jail. Okay, if you pay your $60 on time, I'll take that 1 day away. You pay your $80 for court collections on time, I'll take that away. If you do your 20 hours, I'll take the third day in jail away. If you don't do the $60, it's gonna cost you a day in jail. If you don't do the $80, that's gonna cost you a day in jail. If you don't do the 20 hours community service, that's gonna cost you a day in jail. You understand? Those are your sanctions, okay? I'm gonna have you come back on. Let's come back. March 26th. So that means all of that stuff is due by Friday, March 22nd. All those things have to be turned in. Understand? Courts, are you ready, sir? Yes, sir. Court call CR 22-121, State of Texas versus Andre Nicole Young. All right, Ms. Young, if you'll raise your right hand and place your oath. Ms. Young, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Go ahead. Your name is Andrea Nicole Young, is that correct?
Yes, sir.
Ms. Young, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
Can you tell me about that?
Depression, ADHD, I take medication.
Okay, are you on medication for those today? Like the medications assisting you and helping you have a rational understanding of what's going on in this case in court today?
Yes.
Okay, and in this case, you're represented by your attorney, Mr. Thorson. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to talk with him about the case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork and your plea agreement that you've read over and signed today that you do not understand?
No, sir.
Mr. Thorson, do you believe Ms. Young to be competent?
I do, Your Honor. Just based on her statement to the court, I've represented Ms. Young for a long time now on this case. We've met many times. I am aware that she has a history of depression and is medicated. But at no time in my dealings with her have I had any questions about her competency.
It's good. And you explained to her her rights as they pertain to this case.
Yes, Your Honor, I have.
Have you also discussed with her the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
Do you believe that she understands what deferred adjudication means? In that if she violates any of the terms and conditions of her community supervision, how that process works?
Yes, Your Honor, I have, and specifically in this case where there is an enhancement on punishment. We've had a significant discussion that if she violates, she could face up to 20 years of prison. What would normally be a third degree.
All right, thank you. All right, Ms. Young, I see that you are charged by indictment with prohibited substance or item in a correctional facility. As Mr. Thorson said, which would be a third degree felony. However, the state has alleged an enhancement in your indictment. And if proven true, that would enhance your punishment range to that of a second degree felony, which is not less than 2 years in prison, more than 20 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement is that you would plead guilty to the offense, you would plead true to the enhancement paragraph in exchange for the state's recommendation that the court consider the evidence but not convict you today, rather defer a finding of guilt and place you on community supervision for a period of 6 years, including a $1,000 fine plus court costs, reimbursement fees, and restitution. Is that your understanding of the plea agreement? All right. Understanding the range of punishment in the plea agreement, Ms. Young, I would ask you at this time, how do you plead to prohibited substance or item in a correctional facility?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing the crime?
Yes.
Has anybody threatened, forced, or pressured you to plead guilty to that crime?
No.
Ms. Young, regarding the enhancement paragraph contained in the indictment, it's paragraph 1. Is the allegation contained in that paragraph true or not true?
Yes. True.
And you're telling me that you've reviewed that and what is being alleged in that paragraph is true. And your only reason you're telling me that it's true is because of the fact it is true. You're not just saying that to get a plea agreement, correct?
Correct.
Does anybody threaten, force, or pressure you to plead true to that enhancement paragraph?
No, sir.
All right, the court will accept the defendant's plea of guilt and plea of true respectively. Mr. Thorson, any objection to the stipulation of evidence?
No, sir, no objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir. Thank you.
All right, court's going to review the stipulation of evidence. All right, court, upon reviewing the evidence, finds that there is sufficient evidence to convict Ms. Young of this offense. The court, however, will follow the plea agreement today reached between the defendant and the state of Texas. The court hereby defers a finding of guilt on the prohibited substance or item in the correctional facility. The court finds the first enhancement paragraph to be true, finds that the the degree of offense is elevated to that of a second degree felony. For deferring and finding guilt places Ms. Young on 6 years community supervision. Orders her to pay a $1,000 fine, restitution of $180, court costs of $290, and reimbursement fees. All right, well, I'm going to need you to sign all of these documents, please.
Yes, sir.
Ms. Young, if you'll come forward to be fingerprinted with Deputy Martinez, then you'll step over here with the probation officers and they'll give you information. Yes, you approach, please. All right, we're set for docket call today. Is it my understanding the state has filed a motion to dismiss Mr. Jones's case?
Yes, Your Honor, the victim in the case has filed an affidavit of non-prosecution, has informed us that he's not going to cooperate and we cannot prove the case without it, so we are asking to dismiss.
All right, Mr. Jones, the state having tendered their motion to dismiss, the court grants that. We're free to go.
Sure.
Excuse your honor.
Good to see you, Charlie. Sure, Mr. White, are you ready? Richard Klein, I don't have you on my document. Tiffany Like. Oh, so it's out of order. She may got the 10 o'clock. All right, this is cause number CR 20-259, State versus Tiffany Johnson White. Set with Plea today. Mr. White, you said that this like is wanting to enter into a pretrial intervention contract.
That's correct, Your Honor. We've signed all our documents.
And Your Honor, may I vote?
Yes, please. All right, Ms. Lyke, if you'll do me a favor and raise your right hand, I'm gonna put you on oath now. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? You can or you can. All right, your name is Tiffany Johnson Lyke, is that correct?
Yes, sir.
Ms. Lyke, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with the work that Mr. White's done for you? You feel like you've had enough time to discuss your case with him to the point that you've had all of your legal questions answered? This pretrial intervention contract contains a lot of provisions. Is there anything in here, this paperwork that you've read over and signed that you do not understand?
No.
Mr. White, you believe that Ms. Lyke understands all of the terms and conditions of the pretrial intervention contract and waivers of some of her most important rights there?
I believe she does, Your Honor. I believe she's confident today to make those decisions.
Thank you, Mr. White. And Mr. White, do you believe that Ms. Lyke is intentionally and knowingly and voluntarily waiving her right to a jury trial and also her right to a speedy trial and agreeing to the waiver of expunction?
She is aware of all those matters, Your Honor.
Ms. Lyke, you understand that by entering into this contract, you are waiving your right to a jury trial in this case.
Yes, sir.
You understand that if you go on this contract and later you are unsuccessful for whatever reason and you end up back in court, the state of Texas here can ask the court to set you for a bench trial for the court. And you would not have the ability to have a jury summoned because you will have waived that right as part of the agreement.
I understand.
And your right to a jury trial is a right that cannot be forfeited to you by the court, by Mr. White, by the prosecutors. You and only you make that decision. You understand that?
Yes, sir.
Are you making the decision to waive your right to a jury trial in this case because that is what you're wanting to do?
Yes, I am.
Was anybody threatened to force you to pressure you to waive your right to a jury trial? Does anybody threaten, force, or pressure you to waive your right to a speedy trial? You also understand this, like that, upon entering into this agreement, that you are waiving your right to have criminal record expunged with regards to a few agencies, namely the criminal district attorney's office, and the community supervision and correctional department. You understand that?
Yes, Your Honor.
Meaning that if you successfully complete all of the terms of the contract, you can have your criminal record expunged, except for the records contained and maintained by those two agencies. You understand that?
Yes, Your Honor.
So, understanding all of that, I also see that you're agreeing to enter into a term of 2 years. It's pretrial intervention contract for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, in state jail felony. The range of punishment for a state jail felony is not less than 6 months in prison, state jail prison, not more than 2 years. Also, a possible fine can be imposed not to exceed $10,000. So that is a potential range of punishment that if you violate this contract, you're brought back before the court, you could be susceptible to that range of punishment. You do understand that?
I do understand.
All right. Do you have any questions about the contract whatsoever? All right, the court's going to find that Ms. Light is represented by counsel, that she has intentionally, knowingly, voluntarily entered into this contract. The court finds that she has waived her right to a jury trial, a speedy trial, and agrees to a limited waiver of her expunction rights. The court finds that she has also stipulated to evidence contained here in the contract. Court approves Ms. Light being placed on into the program for the pretrial intervention contract for a period of 2 years. Well, I think it would be best if we were to mark in the defense review, if we were to mark these offense reports as lab reports so that they can be either referenced in the contract as exhibits, so that when they get filed, everybody knows what they are, rather than just being behind the contract. Y'all want to mark those?
Yes, sir, I can mark that.
I have certainly no objection.
I'm not sure they're referred to in here as an exhibit. If you just want to mark them as exhibits with this clause, I believe your looks like your stipulation. So exhibit A is the qualification contract. B is the stipulation of evidence. D is the waiver of speedy trial. So order C is the waiver of jury trial. So it looks like you'd be on E. Sure, that's why. So
Absolutely.
all right, Mr. White, do you have any objections to these exhibits being offered supporting this contract?
No objection.
I think Mr. White, there being no objection, these exhibits will be included into the particular contract. All right, Ms. Sly, you'll come forward and meet with the probation department. They'll give you information about the next step.
Okay.
Is that all you have, Mr. White? Thank you, sir. For the record, clause number CR 23-215, state versus Michael James Glasgow. Set for pretrial today, he's confirmed. Yes. Anderson County Jail. We'll have to reset that to February 29th. Pretrial. Let's wait to see, do we know he's been funded? Let's wait to see if he's still in jail. If he's still in jail, we'll just reset that day. Work on a bench one day. Go ahead for the record, clause number CR 2352, state of Texas versus Wendy Marie Ball. Show that she's in TDC, Army unit, want to finish on her back. Vote.
Yes, Your Honor, if we could get a bench warrant, we'd like to go ahead and proceed on the MPR.
All right, court will set, Mr. Paul for March 26th.
And Your Honor, on this call, because she's incarcerated, would it be appropriate to go ahead and appoint her an attorney now or go ahead and wait?
I'm gonna wait. I'm not gonna appoint her until either A, she makes her request, or B, she's back in her custody. So I'm waiting.
Thank you, sir.
Ryan Klassen. All right, this is sanctions court hearing CR 22 -59, state versus Ryan Klassen. See, Mr. Klassen been on probation for a DWI Class B misdemeanor deferred, and have been convicted of that offense. You're on probation until February of 2025, so you have a little more than a year to go. I've got a note here that you tested positive for alcohol early last month, and you signed an admission that you consumed alcohol. Is that correct?
Yes, sir.
All right, Mr. Klassen, this is your first time in sanctions court, correct?
Yes.
Do you know what the purpose of sanctions court is?
No, sir.
Let me give you a brief overview of what sanctions court is. Sanctions court is a program that is designed to prevent people who have either fallen behind on their probation conditions or they violated their probation conditions, but to try to prevent them from being revoked and sentenced to jail and or prison. So it's basically a second chance program. With the second chance comes criminal sanctions for violations, right? And violations such as they're all categorized. Certain violations are going to have more serious sanctions than others. Not doing your community service is going to be dealt with differently than consuming alcohol. Okay, so the program is designed to detect non-compliance with probation and hopefully interfere with that and try to get you back on the road to successful compliance and then hopefully successful completion of community supervision. So there's many people on probation that are violating that have not reached that level of a revocation and find themselves like you have in a sanctions court. Usually it's money, usually it's community service, testing positive for marijuana, testing positive for alcohol. The sanction for your violation, should you choose to accept it, would be 3 days in jail for your violation. What that means is if you do your 3 days in jail as a sanction, then you can remain on your community supervision. And I'll continue to have you come to the sanction court, monitor you, make sure that you're fine. You don't have to accept that. Tell me if you don't want to accept that, then I'll refer it back to the probation department, probably refer it to the state for a motion to revoke. And we come in here and talk about revocation of your community supervision, which the state would have to prove. Understand all that?
Yes, sir.
So your sanction is 3 days in jail. I'll go even further and I'll let you pick the 3 days that you do. So it doesn't interfere with work. If you have a job, you work.
Yes, sir.
You work Monday through Friday.
Monday through Saturday.
Monday through Saturday. So, with this sanction, I'll let you pick the 3 days that you do.
Okay. Yeah, that was gonna ask that. The 23rd, February
That's okay.
20th.
I'm gonna let you come back.
Okay.
They're gonna write it down. They're gonna produce an order on the sign. They're gonna give you a copy of it.
Okay, thank you.
And then you're gonna have to show up at the jail with that order and your ID. Without the chin.
Okay.
Okay. So you have an opportunity here to plead your probation within the next year and have it taken off your record. In years past, deferred is a new animal for DWI. We used to not have it. You get a DWI conviction, that's it. There's no deferred, there's no chance to get it off your record. You have a great opportunity to have it taken off of your record if you complete your community supervision. So now you've received, really, this is already your second chance. First chance was commit the offense. We gave you the first chance on deferred probation. So you can do it. And now here you violated, yet I'm giving you a second opportunity. It's not playing baseball here. We're not doing 3 strikes. Understand?
Yes, sir.
All right, so this to be the last time that you're in here. Okay.
Yes, sir.
All right, I'm gonna have you come back on March 26th for compliance. You have 3 days done before March 26th. Anything else your probation officer tells you, okay? Okay. All right, come over here and meet with these officers and they'll get those days figured out. Mr. Layhoff? Mr. Layhoff, we're here on your sanctions. The last time we met was back in December 12th. Told you to do 20 hours of community service and pay $120 to probation. My records say that you did not pay the $120 to probation and that you came up short on your community service by an hour and a half. What do you say to those?
Yeah, so I don't get paid until the 5th of this month. I get paid by monthly, every 2 weeks, so every 5th and 20th, and I don't get paid till the 5th of this month, so I can't make the payment to the 20th, to the 5th, sorry.
But didn't you get paid on the 20th of January?
Yeah, I had to pay, I have bills to pay, sir, my rent and stuff, and I was in the process of eviction as well.
Did you get evicted?
Yeah.
You did? Do you have a new place to live? So you didn't pay anything on your probation?
I couldn't make the payment, no, sir.
All right, so this is what we're gonna do, Mr. Layhoff. Falling further behind by not paying.
I can assure you that by the 5th, the payment will be made, possibly with the whole one for this month as well.
I want to bring you back on March 26th
Yes, sir.
And this is what you have to have done. You have to pay $250 to probation. Okay? You have to work 30 hours community service. Okay? And what I'm gonna do is, if you don't pay the $250, that's gonna cost you 3 days in jail. If you don't do the 30 hours community service, that's gonna cost you 3 days in jail. So that's gonna be 6 days total. Okay? Are you gonna be able to comply with that?
Yes, sir.
Remind me, where are you working? What are you doing?
Bell bonds,
Bail bonds, where at?
Dallas,
Are you a bail bond agent? You work for a bail bonds company?
bell bond agent.
Agent. So you're not writing bonds, you're just working for the person.
Yeah, just working for the company.
Is that a full-time job?
Yes, sir.
All right, we're gonna come back on March 26th. Let me sign this notice here. All the things. Mr. Leon, the last thing I want you to do is I want you to go over to the probation department today and give me a hair follow-up drug test, okay?
All right, sounds perfect. Thank you.
All right, you know what probation is, right? All right, do that right after court. Good morning, Ms. Bill. Good. Okay, good. Sorry about that. Yeah, sometimes I'll just hop into that real quick. Mr. Schmidt, the attorney, is on his way in. So we'll get started in just a second. I'll go ahead and swear you in. If you'll go ahead and state your name and license for the record. Ms. Bill, if you'll raise your right hand. Ma'am, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, Mr. Schmidt, I have Ms. Bill, our court interpreter, ready to go. Which client do you want to call first?
I've got Mr. Rodriguez Miranda, I got Punez Rivera and Jose Punez ready to go. So
Jose Martin Funes, CR 23-126. Okay, Mr. Funes, just make sure you speak up loudly so Ms. Bill can hear you, okay? All right, go ahead, Mr. Schmidt.
Judge, I
Except for
believe,
Dr. Cole.
except for docket call today, we're gonna ask for an additional docket call. I've been in negotiations with the state. I think we've reached an agreement. But I need to meet with, my Spanish speakers at my office with an interpreter and make sure they understand, all the ins and outs of that before we proceed. So if we could get a 30-day reset, we'll probably be ready to take care of that when we come back.
March 26th.
That's all right. I can't do March 26th. We can do sooner than that.
It'll be 30 days. I can do February 27th.
February 27th. Great.
All right, court says Mr. Munoz, Jose Martinez for a docket call on February 27th, 9 a.m. No, I'm sorry, let's do 10 a.m.
Yes, sir.
Let's do 10 a.m. So it'll help me with my interpreters.
First, thank you.
And Mr. Schmidt, Mr. Munoz, I show that you're delinquent in your fees, pretrial fees. You pay those today, you're delinquent $240. You make a payment today. Pretrial release.
And Judge, do you show whether or not those fees are for pretrial supervision or attorney's fees? I do know that I'm retained. And so
I'd have to inquire. It's a good question. He's only been indicted, well, I don't know when he was appointed. It's the date of offense, alleged offense is March, so at most, it's gonna be $10 a month, $120.
yes,
At most, so it's probably attorney fee being calculated.
yes, sir.
It shouldn't be.
Yes, sir.
All right, so that's fine. I'll see you back on February 27th.
No, attorney, just,
I know, but is
No.
That's just.
yeah, it was,
Let's get off orange. So it's. Have you been on programs? Luis Miguel Nunez Rivera. Same announcement.
It is the same announcement, Judge, for Mr. Funes Rivera's, benefit. We have been negotiating. We're going to meet in my office with an interpreter to make sure he understands his rights as well as the requirements of the plea agreement, and then come back on February 27th, hopefully with a resolution.
My apologies, Ms. Bill. We got started a lot sooner than we gave you time to establish contact with Mr. Rivera. Does he understand that? Have any questions? Did he tell you that he had any questions when you asked him? Okay. Just tell me he needs to speak up. If they whisper, it's gotta go through that microphone.
Louder.
Just ask me if he has any questions.
No.
Does he understand that we're coming back to court on February 27th and he needs to meet with his attorney, Mr. Schmidt? as Mr. Schmidt schedules. All right, thank you. Lesky Rodriguez Miranda. Take it. Next, this is cause number CR 23-131, State versus Lesky Rodriguez Miranda, set for docket call. Mr. Schmidt, my understanding is a co-defendant with the other two, same announcement.
That is correct, Judge. We're going to reschedule it for February 27th to come back to court, and during that, between now and then, they're all going to meet with me with an interpreter to go over what we've got going on.
All right, court sets Mr. Rodriguez Miranda for docket call on February 27th. After he signs, it's ready to go. Court call CR 23-130, State versus Lazo Danielle Manzanares. My understanding that Mr. Manzanares is not present today.
It's my understanding he's not present at this point in time. I've been talking to his bondsman as well as the co-defendants. It appears as though he missed the bus from Houston. Going to double check, see. I told him if he could get him here to do so, but right now he's not here.
Do you know when you plan on meeting with these individuals in your office?
Probably either this Saturday or the next.
So what I'll do is I will take a nice eye under advisement. I know that Mr. Manzanares has been here at every other court appearance, so I'm going to give him the benefit of the doubt. I'm going to take that nice eye under advisement. He needs to appear via Zoom by contacting Ms. Abraham, and I'll give him until Monday of next week by 5 p.m. This will just contact Ms. Abraham, and then she can set up a Zoom, and Mr. Deputy Martinez can assist with the language issues. All right, Ms. Bill, I think that concludes all of our Spanish speakers today. Am I correct? Until this afternoon. So, Ms. Bill, that's all I have for you. Thank you. I appreciate you being with us this morning. Thanks. Have a good morning. Mr. Schmidt, we'll go ahead and set Mr. Manzanares for docket call that same day, February 27th.
I'm ready on some announcements on a couple other commitments.
Yeah, Bill, coach. All right, Mr. Schmidt, who else you ready on?
Ready on Joshua Nowak.
Mr. Nowak. This is cause number CR 23-65, pretrial.
Judge, prior to announcements, can I?
Yes.
Judge, on Mr. Nowak's, are we ready? So,
Yes.
we've had several pretrial settings, gonna request another pretrial setting for a couple different reasons. One of the reasons are, continue to be digital evidence. There's a high likelihood, I think, after discussing the case with Ms. Curry, that, that digital evidence isn't likely to be analyzed anytime soon. And she and I had discussions of a, alternative way to move the case forward, which we're in agreement with. The court has provided us with funds to do that. And we're going to attempt to get that done here in the next 30, 60 days. Requires a third party expert. So we're going to ask for an additional pretrial setting as far out as the court will grant us.
Okay, March 26th,
Won't be here on March 26th, Judge.
April 16th.
Yes, sir.
All right, court says Mr. Nowak for additional pretrial,
Yes, sir.
additional pretrial, April 16th at 9 a.m. After you get your notice of appearance, I want you to report to your probation officer on this Clark right after court, okay?
Yes, sir.
And also discuss with her if you're showing you're delinquent on your pretrial release fee. So you can make a payment today, I want you to make a payment today, but meet with her right after court.
Okay.
Okay.
Dallas Hightower.
Mr. Hightower. All right, this is cause number CR 23-217, State versus Dallas, Justin Hightower for pretrial.
Judge, we don't have any contested pretrial motions at this time. I believe we're pretty close to reaching a resolution with the state. Mr. Hightower go through that and we're likely to resolve it when we come back. So for now, I'd ask the court to set us for a docket call.
February 27th.
So
All right, court says Mr. Hightower, pretrial, February 27th at 9 a.m. Oh, I'm sorry, did I say pretrial?
I put docket call.
Okay, I meant Dr. Call.
So, sir.
I did write down. Description.
Ryan Dancer.
Ryan Dancer. Says, cause number CR 22-63, Ryan Chance, Dancer. Go ahead, Mr. Schmidt.
Judge, we were initially set for a plea today. For whatever reason, we didn't get that prepared. I need to speak with Mr. Grant more. I'm going to ask to reset his plea for, February 27th.
All right, court sets Mr. Mr. Dancer for plea on February 27th. I want this to be the last setting for Mr. Dancer.
Yes, sir. We got Mr. Meredith here.
Mr. Meredith. This is cause number CR 23-164, State versus Keith Logan Meredith for Dr. Paul Quick.
Judge, I think negotiations with the state are ongoing. About to wrap that up, but ask for an additional docket call on February 27th.
Any objection?
No objection.
Back court says Mr. Meredith for final docket call February 27th. Mr. Meredith, I show you to be delinquent on your pretrial release by $70. Is that something you can pay today?
Yes, sir. I'm on my way to pay it right now.
Thank you, sir. About Jason McDonald. Oh, TDC, that's what I said. What about, Caroline's?
She's going to plea, she's in a holiday.
She's gonna do a plea.
All the rest of mine, we. Take more of these off.
You said Dustin Howard's TDC,
Yes.
so we need to do a benchmark. We want to set it down, How soon does this thing set down? Setting as early as February 27th, try to get a benchmark now, or we can do March, or I'm sorry, we can do April. Be April. Okay, the court will set Mr. Dustin Blake Howard for arraignment on Tuesday, April 16th. We'll do a bench warrant to TDC. Sir. All right, what is it? Right, Mr. Nix, I see that you completed your sanctions. You did your 3 days in jail from January 5th through January 7th. And you also did 3 days in jail, January 19th through January 21st.
Yes, sir.
So at this time, I'm just going to remind you to make sure that you're making your counseling priority. I'm going to release you from sanctions court this time.
Yes, sir. Yes, sir. I was in counseling on Tuesday. Yes, sir. I got reminded. I'll be going back.
All right. Just know that if you slip up, violation, positive drug test, basic counseling, whatever, they're going to send you right back in.
Yes, sir.
All right, I'm free to go.
Thank you, sir.
All right, court's going to stand in recess. Give Mr. Schmidt time to get his paperwork completed. Probably going to be about 20 minutes or so. So I'll report back about 10. This is cause number 2021-192, State versus Jonathan Jefferson Curtis. Mr. Curtis, if you raise your right hand. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand. Mr. Curtis, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's service for you?
Yes.
Like you've had enough time to talk to him about the case and you understand everything that you read and signed?
Yeah.
Mr. Schmidt, you believe you're trying to be competent
Yes, sir.
and you explained to him his rights in this case?
Yes, sir.
All right, Mr. Curtis, you are charged with accident involving damage to the vehicle, like Class B misdemeanor. It looks like the plea agreement is that you would plead guilty in exchange for the state's recommendation that you be convicted of that offense, sentenced to 2 days fine in the county jail with credit for time served, a $1,000 fine, $270 court cost, and $80 of reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
And I'm assuming, Mr. Schmidt, you're retained, is that correct?
That's correct.
All right, Mr. Curtis, doing for Class B misdemeanor is confinement in county jail for up to 180 days and a fine up to $2,000. This time I would ask you, how do you plead to accident involving damage to the vehicle greater than or equal to $200?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing the crime?
Yes.
Is anyone threatening force suppression? You plead guilty.
No.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial question. Anything further from the state?
Nothing further.
Anything further from the defense?
No, sir.
All right, all these papers say county court of law, so we need all those to change to 294. Of course, reviewing the evidence. Court finds sufficient evidence to convict the defendant. Court calls a plea agreement. Court hereby convicts Jonathan Jefferson Curtis of accident involving damage to a vehicle greater than or equal to $200. The court assesses his punishment in 2 days confinement in the county jail, gets him credit for 2 days time served. Orders him to pay a $1,000 fine, $270 court cost, and $80 in reimbursement. Mr. Curtis, you hereby remanded to the custody of the sheriff, so to carry out the terms and conditions of the sentence. I'm happy to come forward and be fingerprinted. Mr. Schmidt, I'm gonna need your signature as well as the state signature. Carrying lines. All right, this is cause number CR 23142, State of Texas versus Karen Lyons. Ms. Lyons, you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Ms. Lyons, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt, for legal purposes. Provided anything about the word that you've read over and signed today, the agreement that you do not understand.
No.
Schmidt, you believe Ms. Lyons to be competent?
Yes, sir.
You've explained to her rights to this case.
I have.
Ms. Lyons, you are charged by indictment with a third-degree felony offense of engaging in organized criminal activity that does carry a range of punishment of not less than 2 years or more than 10 years confinement. The Texas Department of Justice. Also, a possible fine not to exceed $10,000. I see the plea agreement is that you would plead guilty to this crime in exchange for the state's recommendation that the court defer a finding of guilt that does not convict you, place you on probation for 3 years. Court cost, reimburse other fees and restitution. Is that your understanding and agreement?
Yes.
All right, Ms. Lyons, how do you plead to engaging in organized criminal activity?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Anybody threaten force or pressure you to plead guilty?
No.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No, sir.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial request. Anything further from the state?
No.
Defense?
No, sir.
All right, let's reviewing the stipulation of evidence. All right, court finds that there is sufficient evidence to convict the defendant of this offense. The court follows the plea agreement, confirms the finding of guilt, places Ms. Lyons on 3 years community supervision, return to pay restitution of $1,569.95. $290 court costs, $535 of reimbursement fees. The court dismisses under section 1245 Texas Penal Code, Wood County causing 41662A class of misdemeanor possession of stolen check. Is that something that Wood County has conferred jurisdiction in this case for this court to do?
Sir, I'm not certain that they confer jurisdiction. I do know that the DA's office in Wood County had agreed to allow us to 1245 their case into this one, and they have signed off on that admission of unadjudicated items.
All right, that's what I'll, okay. All right, Ms. Lyons, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted, after which you can talk to the probationers, probation officers about the next steps. Deanna Williams. Cause number CR 2145. All right, Ms. Williams, you were originally charged with a state jail felony offense of abandoning or endangering a child, criminal negligence. However, I see in this cause that you are wanting to plead to the court to a different charge, the same charge but reduced to Class A misdemeanor, which does carry a range of punishment which cannot exceed 365 days in county jail or a fine more than $4,000. Ms. Williams, are you a United States citizen who reads, writes, and speaks English?
Yes,
If you'll raise your right hand now, do you swear that the testimony you give to the court today is the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Ms. Williams, you're represented by your attorney, Richard Schmidt. Are you pleased with this legal services?
yes,
Got enough time to talk to him about the case? You understand everything that you read and signed today?
yes,
I can see that the plea agreement is that you would plead guilty to that charge. State's recommending that the court convict you of that offense as a Class A misdemeanor, assess your sentence at 2 days confinement in the county jail with the credit for time after this written, plus fines, court costs, and reimbursement fees. Is that your understanding as well? All right, Mr. Schmidt, you believe Ms. Williams to be competent in agreeing with this plea agreement?
Yes,
All right, Ms. Williams, how do you plead to abandoning and endangering a child?
guilty,
You plead guilty to that crime because you are guilty of committing that crime.
yes,
Does anybody threaten, force, or pressure you to plead guilty?
no,
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objections to the stipulation of evidence?
no objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial profession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
For reviewing the stipulation of evidence. Finds that there is sufficient evidence to convict the defendant, or hereby follows the plea agreement, convicts Deanna Williams of abandoning or endangering a child with negligence, or assesses her punishment under section 1244B, Class A misdemeanor at 2 days confinement in the Van County Jail with credit for time served. Orders her to pay a $500 fine, $585 reimbursement fees, and $270 each. Ms. Williams, you hereby remanded to the custody of the sheriff so you can carry out the terms and conditions of the sentence. Please come forward to be fingerprinted. Mr. Hartwell, I don't think you've signed any of these pleas, so at some point you need to go to the clerk's office and sign this.
Yes, sir.
Okay, Christopher Ryan Nash. CR 21388. Mr. Nash, will you raise your right hand? Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Over again, Mr. Nash, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of medical condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Richard Schmidt's legal services?
Yes, sir.
Like you've had enough time to talk to him about your case and understand everything that you've read and signed?
Yes, sir.
Mr. Schmidt, you believe Mr. Nash is competent?
I do.
You explained to him his rights as they pertain to this case.
Yes, sir.
Mr. Nash, you are charged by indictment with a third-degree felony offense of driving while intoxicated. Third or more offense. It does carry a range of punishment of not more than 10 years in prison and not less than 2 years in prison, and a fine not to exceed, if imposed, not to exceed $10,000. Now, is there a enhancement paragraph that the defendant's pleading truth in this case at all?
No, sir. It's been abandoned by the state.
Straight to third, okay. All right, so Mr. Nash, I see the plea agreement is that you plead guilty. The state's recommendation is that your punishment be assessed at the maximum 10 years in prison, but they're recommending that that sentence be suspended. You be placed on probation for 10 years, paying a $7,500 fine plus restitution and court costs and reimbursement fees. Is that your understanding?
Yes, sir. Yes, sir.
All right, Mr. Nash, how do you plead to driving while intoxicated third or more offense?
Guilty.
Are you pleading guilty to that offense because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objections to the stipulation of evidence?
No, sir.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, court will review the stipulation of evidence. All right, based on stipulation, the court finds that there is sufficient evidence to convict Mr. Nash of this offense. The court does follow the plea agreement today. Convicts Mr. Christopher Ryan Nash of driving while intoxicated third or more. A third-degree felony offense assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence today and place him on 10 years community supervision. Orders him to pay a $7,500 fine, $60 restitution, $209 court costs, and $615 in reimbursement fees. And the court notes that the state has abandoned this paragraph contained in the. Mr. Nash, you hereby remain in custody of the sheriff so we can carry out the terms and conditions. I'm sorry, to the custody of the probation department so they can carry out the terms of the sentence. I'm gonna have you come forward. Mr. Schmidt, there's a couple places you can sign as well.
Yes, sir.
Brad Brewer, CR 23-6. All right, Mr. Brewer, if you'll raise your right hand and place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Your name is Brad Andrew Brewer, correct?
Yes, sir.
Mr. Brewer, are you a United States citizen who reads, writes, and listens?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and his legal services?
Yes, sir.
Is there anything that you don't understand about your plea agreement that has been signed today?
No, sir.
Mr. Schmidt, you believe Mr. Brewer to be competent?
Yes, sir.
You've explained to him his rights pertaining to this case.
Yes, sir.
You've also explained to him the advantages and disadvantages of the deferred adjudication.
I have.
You believe that he is entering into this intentionally, knowingly, and voluntarily.
Yes.
Mr. Brewer, you are charged by indictment with a state jail felony offense of theft of property greater than $2,500, less than $30,000. That does carry a range of punishment of not less than 6 months in prison or more than 2 years in prison, and also a possible fine not to exceed $10,000. I see the plea agreement is that you would plead guilty to that in exchange for the state's recommendation that the court not convict you today, but rather defer a finding of guilt and place you on community supervision for a period of 3 years with a restitution order of $6,000 plus court costs and reimbursement fees. Is that your understanding as well, Mr. Brewer?
Yes, sir.
All right, Mr. Brewer, how do you plead to theft of property greater than $2,500, less than $30,000?
Guilty.
Mr. Brewer, are you pleading guilty today to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objections to the stipulation of evidence? Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, the court's reviewing the stipulation of evidence. All right, the court upon reviewing the evidence finds that there is sufficient evidence to convict the defendant. However, the Court will follow the plea agreement, will hereby defer the finding of guilt, places the defendant on 3 years community supervision, orders him to pay $6,000 restitution, $290 court costs, $535 reimbursement. Mr. Brewer, you're hereby remanded to the custody of the probation department to carry out the terms and conditions of the Senate. Have you come forward to be banned, and then you can talk to the probation officer about the next step. Yes, please. Mr. Demus. This is cause number CR 23-85, State of Texas versus Guido Johannes Dingemans. Mr. Dingemans, feel ready to right hand, sir. Can you hear me okay? Can you hear me okay?
I don't know very well.
All right, Mr. Schmidt, y'all come on up. If you'll bring a microphone, if you don't mind, just. Is this better, Mr. Dingemans? Can you hear me better? All right, Mr. Dingemans. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Your name is Guido Johannes Dingemans, is that correct? Mr. Dingemans, are you a United States citizen who reads, writes, and speaks English? Are you a United States citizen who reads, writes, and speaks English? You're a permanent resident. Do you understand that a plea in this case today could affect your legal status within this country?
Yes, sir.
Okay. In this, have you ever been diagnosed with a mental condition?
Dental, yes.
Okay, what have you been diagnosed with?
Suicide.
Okay. Are you currently on any type of medication, undergoing treatment for that? Do you feel like you understand everything that's going on in court today? You understand everything that's going on in your case? You're represented by your attorney, Mr. Richard Schmidt. Do you feel like you've had enough time to talk to Mr. Schmidt about your case? Do you feel like you've had enough time to talk to Mr. Schmidt about your case? Do you understand everything that you and he have discussed about your case? Is there anything that you don't understand?
Other things, the fines I have to pay, I have no income right now. Because at my green card, I lost it in the fire and I applied for another one. I tried to get social security going, but as long as I don't have my green card, I can get my social security coming. So I have no income. My friend's helping me out right now.
Okay.
I have no income whatsoever.
And I understand that. So it's not that you don't understand that you have to pay the fines. You're just telling me that you have a hardship.
I don't have it.
Mr. Schmidt, you believe Mr. Dingemans to be competent? I do. And you've explained to him his rights as they pertain to this case? Yes, sir. All right, Mr. Dingemans, you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more offense. That does carry a range of punishment from the minimum 2 years all the way up to a maximum 10 years of prison and a possible fine not to exceed $10,000. I see the plea agreement in your case is that you will plead guilty to this crime. The state's recommending that the court convict you of this offense, sentence you today to 5 years confinement in prison, but they're recommending that the court suspend that sentence today and place you on 5 years of community supervision. They're also asking the court to order you to pay the $7,000 fine plus reimbursement fees and court costs. Is that your understanding of the agreement? All right. Mr. Dingemans, understanding that, how do you plead to driving while intoxicated, third or more offense?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
So,
Are you pleading guilty because you are guilty of committing that crime?
no, I did it different.
You committed the crime. Has anybody threatened you, forced you, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state
No, Your Honor.
on the defense? Yes. All right, of course, we'll review the stipulation of evidence. All right, the court finds that there is enough evidence to convict Mr. Dingemans of this offense. The court will follow the plea agreement. The court hereby convicts Mr. Dingemans of driving while intoxicated, third or more offense, a third-degree felony. The court assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence today pursuant to the plea agreement and place Mr. Dingemans on 5 years community supervision. The Court orders him to pay a fine of $7,000, court costs of $290, and reimbursement fees of $535. Mr. Dingmans, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. So what I want you to do with regards to your fine is you talk to your probation officer and let them know what you're going through until, as long as you're making an effort to try to get that paid and taken care of, they will work with you on the fine, okay?
Thank you, Your Honor.
You're welcome. Go ahead, step over there and let the deputy fingerprint you, please. Mr. Schmidlkopfer, if you'll come forward, please. Yes, sir. All right, this is file number CR 23-165. Mr. Schmidlkopfer, if you'll raise your right hand, please. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Oh, your name is Daniel Gage Schmidlkopfer, is that correct? And Mr. Schmidlkopfer, are you a United States citizen who reads, writes, and speaks English? Yes, sir. Have you ever been diagnosed with a mental condition? You're represented by Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's work for you? Yes, sir. You believe you understand everything that you've read and signed as part of your plea agreement? Mr. Schmidt, do you believe Mr. Schmidlkopfer to be competent?
I do.
And you've explained to him his rights regarding this case, as well as the advantages and disadvantages of the deferred adjudication plea?
Yes, sir.
Mr. Schmidlkopfer, you are charged by indictment with a second-degree felony offense of burglary of a habitation that does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison, carries a potential fine not to exceed $10,000. I see the plea agreement in your case is that you plead guilty to that fine. State's recommending that the court consider the evidence and not convict you, but defer a finding of guilt, and place you on 4 years of community supervision with restitution of $1,240 plus court costs and reimbursement fees and a $600 fine. Is that your understanding of the plea? Yes. That's what you're asking the court to approve? Yes. All right, Mr. Schmidlkopfer, I'm going to ask you, how do you plead to burglary of a habitation? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Yes. Anybody has threatened which you are guilty here today? All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objections to the stipulation of evidence? Stipulation of evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, court's going to review the stipulation of evidence. I've had 2 sets of conditions of probation. We know.
Judge, I don't know, we got pulled out quickly. I attached one of them signed and we went over. I don't know if the other one was just a copy or if it was something added. I don't think it's
the same thing. All right, Mr. Schmidlkopfer, based on the evidence before the court finds that there is sufficient evidence to convict you of this offense. The court hereby follows the plea agreement, defers a finding of guilt on the second-degree felony offense of burglary of habitation, places the defendant on 4 years community supervision, orders him to pay a $600 fine, restitution in the amount of $1,340, court costs in the amount of $290, and reimbursement fees of $535. Mr. Schmidlkopfer, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted, and then the probation officers would give you more information about what's going on. Mr. Fulbright. All right, this is file number CR 22-214, CR 23-38, CR 23-139. I know that we were set for a plea today. Announcement, Mr. Schmidt.
Judge, we were set for a plea. I asked the court to set up for a plea the last time we were here. After discussing the paperwork with Mr. Fulbright, it's my professional opinion that we needed to put a pause on that plea and give us an opportunity to go through it in more detail prior to him executing the documents. I've spoken with the state about that. They are going to leave the current plea offer open to give us an opportunity to go through it and either enter a plea or proceed to trial, one of the two. So we'd ask for a docket call setting on that February 27th date.
All right, court sets Mr. Fulbright for final docket call on February 27th.
Is he free to leave, Judge?
Free to go. TR 23-151, State versus Jason Wayne McDonald, Mr. McDonald, custody of the Texas Department of Correction, going to reset that case for arraignment on March 26th. I know. We will execute it. Court call CR 23-83, State versus Preston Mitchell Wilson. Court finds that he is county a federal detainer. Court's going to set that for status as a federal detainer on March 26th. Okay. Yes. Okay. So is that everybody on the call?
I have Taylor dates. He's been weird. He's so this my question is, when do you
All right, court's going to stand in recess till 2:30. The court will know for the record. I'm sorry, court will stand in recess till 1:30. Court finds for the record that Basso Danielle here as order. That thing has been called out and extended 3 times without no response. The court will issue a judgment not citing. I think that issuance under advised until Monday next week 5 p.m. Mr. Montanaro said that we were instructed through counsel to appear via Zoom with courts for the reason for 1:30.